Hello learners, welcome back to your education channel Learn and Educate. In the previous video, we have learned about section 100 and section 100A under the part 7 appeals under heading appeal from the appellate decrees. Section 100 second appeal. Section 100A no further appeal in certain cases. Now section 101 second appeal on no other grounds. No second appeal shall lie except on the grounds mentioned under section 100. No second appeal can be made except only on the grounds which is mentioned under section 100. All those five conditions mentioned in section 100, that the High Court shall determine from any decree, an appeal shall lie to the High Court from any decree which is passed in any appeal by any court subordinate to the High Court, and if the High Court is satisfied that the case involves a substantial question of law. Second, an appeal may lie under this section 100 when an appeal in a decree is passed ex parte. Third condition of section 100. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law which is involved in the appeal. Fourth condition of section 100, where the High Court is satisfied that the substantial question of law is involved in any case, and it shall formulate that question. Condition fifth of section 100, the appeal shall be heard on the question which is formulated, and the respondent at the hearing of the appeal be allowed to argue that the case does not involve such question. Now section 101 second appeal, that was I was explaining. Section 101 second appeal cannot be made on any grounds except those four conditions which I mentioned just earlier. Except those conditions, second appeal cannot lie. Section 102 no second appeal in certain cases. The few cases where second appeal can never be made, where the original suit involves the subject matter is recovery of money which does not exceed 25,000 rupees. In that case, no second appeal shall lie. No second appeal can be made where the original suit is for a recovery of money not exceeding 25,000 rupees. Section 103 power of High Court to determine issue of facts. In any second appeal, when the High Court is of the evidence with the sufficient record that it determines an issue which is necessary for the disposal of the appeal, which A has not been determined by the lower appellate court or both by the court of first instance and the lower appellate court. The High Court is evidence on record that any issue necessary for the disposal of the appeal has not been determined by either by the lower court or by the court of first instance and the lower appellate court. B, with that issue has been wrongly determined by the court, such courts or court of by reasons of a decision of question of law as referred in section 100. As referred in section 100, it has wrongly been determined by the such courts as to the decision involves question of law. As the section 100 states that when the High Court is satisfied that the question involves a substantial question of law, the case involves a substantial question of law, and that has been wrongly decided. As per section 103b, power of High Court to determine an issue of facts when it has wrongly been decided by the courts as to a question of law as referred in section